Prashant Bhushan will speak on the topic. Thank you.
Thank you for the introduction. Good morning, friends. Can you hear me clearly?
Yes, sir. Yes, sir. We can hear you.
Okay. So, before we get into what is happening in the judiciary today, we need to understand what is the role that the judiciary has been assigned under our constitution. So, the judiciary in general has two roles. One is to decide disputes between citizens and the state, etc., and between states also. The other, equally, if not more important role of the judiciary is to be the guardian of the constitution and to protect the fundamental rights of people, to ensure that the state and no authority violates fundamental rights of citizens, to ensure that the state does its duty, to ensure that the legislature does not exceed the bounds of its powers under the constitution. Therefore, to strike down laws which are unconstitutional. This is the second very important role of the judiciary, which is called its regulatory function, apart from deciding disputes. Now, if we look at what is happening to the judiciary today, that is whether disputes are being decided, whether they are being decided expeditiously, whether they are being decided correctly, whether to what extent is justice being done in terms of its role of deciding disputes. Now, the answer to that would be quite dismal, because if you ask the question, what percentage of people in this country are able to get justice through the judiciary, the honest answer to that would be very few, probably not even 1%. The reason for that is that firstly, the vast majority of the people in this country cannot even access the judiciary, meaning that they do not have the money to engage lawyers, and therefore they can't access the judiciary, and therefore they cannot take their disputes to the judiciary. If somebody has violated their rights, they can't take the matter to court. If they have been unfairly targeted or abused by the police, for example, if the police registers a false case against a poor citizen of this country, he is helpless. He can't even defend himself adequately or effectively in the absence of lawyers, and therefore he just stands in front of the court by holding his hands in front of the police people, and he just says that, please have mercy on me. He can't fight for his rights. So 80% of the citizens of this country would fall in this category, who cannot really approach the courts or defend themselves. The remaining 20%, even if they can go to court, they find that their cases go on forever. They take an extraordinary amount of time. They keep getting dates. Instead of the case getting decided, they just keep getting adjournments. And ultimately, when the case comes to be decided, say after a decade or 2 decades, even then, very often it is not decided correctly, because either the judge is incompetent, or sometimes, and quite often, that the judge is corrupt. So there is considerable corruption in the judiciary. This was found in a Transparency International study which was done in India about corruption perception, and it was found that the people believe the judiciary to be among the most corrupt institutions in this country. So That's the reality, that very, very few people are able to get justice through this system. When we come to the second role, that is the regulatory role of the judiciary, which is given to the high courts and the Supreme Court primarily, which is to ensure that the citizens' fundamental rights and other rights are protected and are not violated by the state, to quash any such action by the state or any authority which violates the fundamental rights of citizens or any other right of citizens, to ensure that the executive does its duty. That is, see, when the executive is given powers, those powers are coupled with duties to exercise those powers when the occasion arises to exercise those powers. For example, if the media is spreading fake news, hate news, which is a crime under our laws, and is thereby misguiding the people, then it is the duty of the state, which is the law enforcement agencies, the police, etc., to step in and to take action against those sections of the media which is spreading fake news, hate news, etc. And if they do not do their duty, then it is the job and the role of the courts to make them do this duty. That is, to force them to issue a mandamus or to issue a command to the authorities, to the law enforcement agencies to act. For example, this has happened recently in the Delhi riots, where the the police is doing two things. Firstly, it is not registering even FIRs or investigating complaints against people like Kapil Mishra, who instigated people to go and kill, against people like this fellow Thakur, that Minister of State for Finance, who also instigated people to go and kill. Those were clearly crimes under our penal code, for which even that Justice Muralidhar in the Delhi High Court told the police that why are you not registering an FIR? Why are you not arresting him? Thereafter, unfortunately, he was transferred. Before he could take the case any further, he was transferred post haste. But that is the job of the police, and if the police doesn't do its job, then it's the job of the judiciary to force it to do its job. Secondly, we are finding that in the Delhi riots case, a lot of innocent people who were just peaceful protesters or students and activists who organized those peaceful protests, they are being targeted by the police, they are being arrested. Even if they get bail, in one case, they are thereafter being arrested in other cases which are fabricated against them. Again, it's the job of the judiciary to step in and to prevent all this from happening, to go into this, because when it's absolutely clear and institutions like the Delhi Minorities Commission have raised this issue publicly, then it is the job of the judiciary to examine this, if this unfair witch hunt is going on, and to take action against the police officers who are responsible for this witch hunt, and to stop this witch hunt. Now, if we examine as to whether the judiciary is satisfactorily performing its regulatory role of protecting fundamental rights, of making the government agencies, including the police, perform their duties, of striking down unconstitutional laws, etc. To what extent is the judiciary performing this role? We will find that at least in the recent past, in the past few years, and particularly in the past few months, the Supreme Court in particular has completely failed this country and its people in performing this role. We can look at many of these instances of these cases. We have the case of, we can start with the case of Kashmir, where Article 370 was virtually done away with. That is, Kashmir's autonomy was done away with, where it was converted into a union territory from a state, and where a kind of lockdown, even a worse lockdown than was put upon the country after this COVID crisis, a much more serious and much more severe lockdown has happened in Kashmir and has been going on now for almost 9 months, more than 9 months. It started in August last year, and now we are in end of May. So started in the beginning of August. So almost 10 months. Kashmir has been virtually in a state of lockdown, where they are denied internet services, or at least proper adequate internet services, etc. So petitions were filed in the Supreme Court challenging the virtual abolition of Article 370, challenging the conversion of Kashmir into a union territory in violation of the instrument of accession, because that was the condition on which Kashmir had acceded to India, that it would have more autonomy than other states. Instead of that, you have now made it into a union territory, and it doesn't even have the autonomy which other states enjoy. So those petitions were filed. Unfortunately, the Supreme Court has kind of dilly-dallied in hearing those petitions, and has not heard those petitions even for the last almost 9 months. These petitions were filed more than 9 months ago, but for 9 months the Supreme Court has not bothered to hear such important petitions. And even on the issue of the internet shutdown, it has been hearing these cases leisurely, and thereafter passing innocuous orders, virtually asking the same government to review whether internet shutdown is still necessary or not, rather than telling the government to restore proper and full internet services within the states. Then we had this Citizenship Amendment Act, which effectively discriminates between Muslims and non-Muslims. And the government announced that they would couple it with a National Register of Indian Citizens. And the process by which this was being done, it was quite clear that a large number of Muslims are likely to be excluded from the National Register of Citizens in a very arbitrary method of doing it. And that was also challenged. The Citizenship Amendment Act was challenged, the National Register of Citizens, etc. also. Again, those matters have been pending in the Supreme Court for the last more than 6 months. We all know that the Citizenship Amendment Act led to widespread protests across the country. Almost all the protests were totally peaceful. There were attempts made to instigate violence by various vested interests, etc. But people didn't fall into that trap and remained totally peaceful. In fact, in these protests, the Constitution was being read, and people were being educated about fundamental rights, about provisions of the Constitution, etc. And thereafter we saw that there was an instigation by BJP leaders, including a minister in the Union Cabinet, including a Delhi leader of the BJP called Kapil Mishra, who enjoys close proximity to Amit Shah and others, He instigated people to go and kill. He said, "Goli maro salon ko," etc., etc. And thereafter, soon thereafter, this kind of carnage took place in Delhi, in which, by and large, Muslims were at the receiving end of this carnage. There are large number of videos which show the police to be complicit with these marauding mobs. And yet, despite many of these matters going to court, that is, of course, the Citizenship Amendment Act, the challenge to that is before the Supreme Court. The Supreme Court has not found the time to hear it in so many months. Thereafter, the police violence at Jamia University took place, where there are videos showing the police entering the campus, entering the library of Jamia, beating up students, breaking up CCTV cameras, etc. Again, that matter was taken to the Supreme Court. Again, they just sort of virtually turned a blind eye, with the Chief Justice saying that he will not hear it unless the violence stops. I mean, what does he mean? Violence was being done by the police and these other people on peacefully protesting students. And yet he says that he will not hear it. When people come with a complaint against the police, he says he will not hear it. Thereafter, this we all saw, everybody watched on videos, these gundas who entered Jawaharlal Nehru University and who were virtually escorted in by the police, and then they indulged in large-scale violence, beating up students and teachers inside the campus. And then there was this whole gunda gang of about 100 people was thereafter escorted out by the police, and nobody has been arrested so far. Again, these matters also went to court. But nothing has been done particularly by the Supreme Court. We saw sedition cases. We have been seeing sedition cases being slapped against people who have just said anything against either the Prime Minister or some chief ministers, etc. People are being charged with sedition, being arrested, and this is going on a very large scale. And yet, though it's completely, charging such people with sedition, Supreme Court had said in 1962 itself that the charge of sedition cannot be sustained unless the person makes a call for violence, for organized violence, to overthrow the state by violent means. But yet people who are just saying something against the Prime Minister or the Chief Ministers, etc., are being charged with sedition and being arrested, though this is clearly their fundamental right of free speech, and yet the judiciary is doing nothing about it. There is large-scale Islamophobia being fueled by large sections of the mainstream media, and yet, these are matters on which the court should have taken suo motu cognizance. People have stopped even approaching the courts on these issues, seeing the response of the Supreme Court. They should have taken suo motu action on this. But nothing has been done by the courts. Activists and students and who were involved in these peaceful protests have been arrested. Instead of arresting the real perpetrators of the violence, who are all seen on video, many of them are seen on video, beating up innocent people, instigating violence. Instead of arresting those people, they are arresting the people who were victims of this violence. And again, we see total or almost total inaction by the courts, especially the highest court of the land, that is the Supreme Court. Then the lockdown happened. Now, one of the immediate impacts of the lockdown was that people, and everybody knew that. Firstly, the lockdown takes place at 4 hours notice. First, for 2 months, nothing is done. It was known the first COVID case in India came at the end of January. Till the end of March, nothing was done. Suddenly on 24th March, at 4 hours notice, a sort of brutal lockdown is clamped upon the whole country, leaving people without jobs, especially daily wagers, without any jobs, without any money, and therefore without any source of food. And thereafter, when they try to go back to their villages, when they go to train stations, bus stations, etc., far from providing them with any method of transport to enable them to go back to their homes, the police is told to pick them up and forcibly put them in these shelter homes, making a mockery of this whole business of social distancing, where hundreds and thousands of people are crammed together in small shelter homes, etc., with virtually no sanitation, no facilities, etc. So we see all this, and these issues are raised by people, responsible people like Harsh Mandar, Aruna Roy, Jagdeep Chokhar, Anjali Bharadwaj, etc., before the Supreme Court. And the Supreme Court is asked that, look, at least provide some wages, some money in the hands of these people who are left with nothing. They are going to starve. The Supreme Court has held that Article 21, that is the right to life, includes the right to live with dignity, which includes having at least the minimum requirements of food, water, shelter, etc. And they should be allowed to go back, travel back, and they should be facilitated to travel back to their villages if they want to go back. If you have left them without any money, jobs, food, etc., then at least allow them to go back if they want to go back. But unfortunately, the Supreme Court did nothing in this matter. Fortunately, however, many of the high courts started passing orders after some time, and today the Indian Express has published that as many as 19 high courts passed fairly good orders relating to at least to the travel of these migrant workers, travel and providing them with food and water. The Supreme Court, however, did nothing. They just chose to believe, have their faith in the government and chose to believe the government. The Solicitor General came and told the court that everything is fine, nobody is on the roads, everybody is being provided, you just have faith in the government, and the court said, all right. And now when so many stories came out in the media about migrant workers dying while walking on the way, walking hundreds and thousands of kilometers, etc., cycling hundreds and thousands of kilometers, dying on the trains, dying on the railway stations, etc., then finally the Supreme Court wakes up and issues suo motu notice on this issue of migrant workers, and now they have passed some order that they should be provided some means of travel and food, water, etc. But they have placed most of the burden of this on the states, when in fact the burden of this should be at the center, which has imposed the lockdown, and it controls most of the money. So it's a rather dismal state of affairs for the Supreme Court. But as I said, as many as 19 high courts passed some useful orders in this during this lockdown, and therefore what we saw during the emergency in 1975, when fundamental rights were suspended, and the issue arose as to whether people can challenge their illegal detentions at all in the courts or not. So several high courts passed orders saying that yes, they can, even during an emergency when fundamental rights are suspended, doesn't mean that the right to move the court is suspended. And therefore, they passed orders quashing these detentions, many high courts. But thereafter, unfortunately, the Supreme Court reversed the orders of the High Court and said that during an emergency, people do not even have right to move the court. At that time, there was this Judge Justice Khanna who gave a dissenting judgment in that, which is today remembered. Of course, recently in that Putta Swami judgment dealing with the right of privacy, the Supreme Court has said that it was wrong. And everybody today respects the dissenting Judge Justice Khanna and does not respect those 4 judges who kind of succumbed to the pressure of the government during the emergency. And the same kind of thing we are seeing today also, that many high courts have passed good orders in the case of these migrant workers, but unfortunately the Supreme Court did nothing until recently, virtually when, and this also the suo moto action happened after the Supreme Court received so many brickbats from not just lawyers and other independent commentators, but also from their own colleagues. Several retired judges wrote articles in the media, gave interviews, etc., saying that the Supreme Court has completely abandoned the poor and the migrant workers and left them to the mercy of God, when in fact it is their duty to protect their fundamental rights, to ensure that the executive doesn't violate their fundamental rights. So therefore, it's a rather unfortunate state of affairs that we are seeing in the Supreme Court. Now, many people ask, why has this happened? Why is this happening? And that has several, in my view, there are several reasons. One is that when the courts are faced with a very powerful government and almost a fascist government, which is what we are faced with today, then the courts usually become weak. And this is what is happening to the Supreme Court at any rate. There are several, because in the High Courts there are many other, there are a large number of judges, and usually there are at least some bold and independent judges, and therefore they are passing good orders. But what happens is that when judges travel up to the Supreme Court, etc., at every stage there is a sieve. And today, with this government, there is a kind of government sieve, because they are virtually not allowing the appointment of bold and independent judges, because they are just sitting on even when the collegium recommends the appointment of some bold and independent judge, by and large, we find that the government sits on that recommendation and does not appoint him, and tries to only allow appointments of judges who are either committed to the government or who are not independent. By and large, this is what is happening. And that is why we see, that is one of the reasons why we see the state of affairs. The other thing is what those 4 judges said in their press conference in January 2018. So they, 4 senior judges of the Supreme Court, held that unprecedented press conference where they said that the then Chief Justice was abusing his powers as master of roster and listing sensitive, politically sensitive and important cases before convenient benches, which had put democracy in danger. Now, you see, and we also saw that there were very, very serious charges made against previous Chief Justices. There was that case of Kaliko Pul, the Chief Minister of Arunachal, who committed suicide, who left a suicide note accusing 2 judges in that bench of demanding bribes from him. And the then Lieutenant Governor of Arunachal recommended that the CBI should investigate these charges, but the government did not allow those charges to be investigated against those at least 2 Chief Justices who became Chief Justice soon thereafter. And against one of those Chief Justices, there was also the charge, which was registered by the CBI in an FIR, that bribes were being demanded for deciding a case of a medical college in a particular way. So we find that this government at least seems to be using its agencies in order to somehow influence and pressurize judges, especially Chief Justices. And once you have a Chief Justice who is under your influence or who has been pressurized, then, as the 4 judges said, you can get all important politically sensitive cases decided in a particular way by using your power as master of roster to list those cases before particular convenient benches, etc. So this also is a problem that appears to have cropped up. So the question is, what is the solution to a judiciary which seems to have kind of collapsed? As I said, some of the high courts, at least some of the benches in some of the high courts, have done good work, but by and large, we are seeing a collapse, at least of the Supreme Court. And what is the solution? So, of course, on this question of sort of slow justice or speeding up justice, etc., one of the things that needs to be done is to have these Gram Nyayalayas. There is a Gram Nyayalaya Act which came many years ago. Unfortunately, that act has not been implemented, which requires the formation of these somewhat informal courts at the sub-tehsil level, that is at the block level. Unfortunately, those courts have not been created, as a result of which ordinary cases also take a long time, and people who do not have lawyers are not able to access those courts. So we need to effectuate that. That case is already there in the Supreme Court. We have filed that case. Let's see what orders are passed in that case. Then we need to improve the system of selecting and appointing judges. We need to have a full-time independent judicial appointments commission, not an ex officio body of sitting judges and sitting law minister, etc., but a totally full-time and independent body of either retired judges or others, which are selected in a manner which can be, where they can be independent of the government. So we need an independent full-time body to select judges, which should function in a transparent manner, so that they lay down a criteria for selection, and thereafter they evaluate people on that criteria in a rational manner, as well as put out the shortlisted candidates on a public website, so that people who have any relevant information about them can share that information with the Appointments Commission. Then we also need a proper system of accountability for judges. Today we only have impeachment, which is an ineffective, impractical way of seeking accountability of judges. We need to have a full-time Judicial Complaints Commission to whom complaints against the judges can be addressed. Again, this commission should be appointed in a manner which can ensure its independence both from the government as well as from the judiciary. But regarding this independence of the judiciary, firstly, we need to change this system of master of roster. Just giving this power of deciding benches to just one person who is the Chief Justice is not a proper system. We had gone to the Supreme Court asking for that there should be a collegium of at least 5 senior judges who should decide the roster rather than the Chief Justice alone. Unfortunately, that petition was not accepted, but we need to change this system. But for all these reforms, we will need to have an active and engaged citizenry, because those who are in power, whether they are in the executive or whether they are in the judiciary, do not really want any serious judicial reforms. they are happy with the current failed system. The judges are getting their salary, and after retirement they get to do all this arbitration, and they make an enormous amount of money in that arbitration, or they get post-retirement jobs which are also given to them by the government. That's another thing. We can't leave post-retirement jobs in the hands of the government. Post-retirement jobs of judges must be decided by an independent judicial appointments commission, not by the government. Government should have absolutely no role in deciding post-appointment jobs for judges. So these are some of the things that need to be done. Other than that, we need to have transparency in the functioning of the judiciary, for which we will need to have sort of videography of all court proceedings, and those videos should be put out to the public. After all, courts are supposed to be public places which people can access and which people can see, and there is no reason why courts should not be videographed and those videos should not be put out. In fact, currently the courts are not even functioning in a physical manner. They are functioning only through video conference. But unfortunately, the Supreme Court has said that, of course, this is not a very satisfactory procedure of functioning, because video conferencing is not, sometimes the video drops, lawyers cannot access, and in any case, other members of the public can't access these proceedings. Litigants can't access these proceedings, and therefore it is necessary that these videos of court proceedings should be out in the open so that anybody can see. And the technology exists for doing that. Unfortunately, this is not being done. And on the contrary, the Supreme Court has recently passed an order saying that the video conferencing or hearings through video conferencing should not be put out before the public, should not be made available to anybody else, only to lawyers. I mean, I find this extraordinary. Firstly, why shouldn't the court resume full functioning? Why shouldn't the court be functioning fully, even amidst this COVID? Because they can have social distancing inside the courtroom also. They can allow only 1 or 2 lawyers for any party. They can allow only the lawyers of 1 or 2 cases at a time inside the court. They can allow only 1 litigant for a party inside the court. But why should there not be resumption of physical functioning? And why should there not be at least video recording and video transmission of court proceedings? I mean, it's extraordinary that this is all this is going on, that you have these court functioning through video conferencing, and the video conferencing cannot be even seen by even the litigants. What to say of the general public? So all these changes would be required, but as I said, for all those changes to happen, we need an active and engaged citizenry. It's only when the citizens raise their voice for these reforms that the authorities will do something. Unless pressure is put upon them, nothing will happen. So I'll stop here. Thank you very much. And I am now open for questions.
Thank you, sir. Thanks a lot. Guru Prasad will now put the questions which have come to us in the private chat box. Guru Prasad.
So there are some questions. I think for the time, I think you have answered most of them or some of them. Still, I'll repeat those questions. You can choose to answer whatever you feel like you have not spoken them. The first question is, how is it that high courts are more proactive and more pro people, but highest court is behaving differently? What is the difference according to you?
Yeah, so to my mind, the reason is that, you see, high courts have many more judges. All the high courts put together have some 700 judges or so. Supreme Court has only 33, 34 judges. Some of the high courts have very independent chief justices, and therefore those high courts are quite active and independent and passing good judgments and orders, giving good judgments and orders. Sometimes even where the Chief Justices may not be very good, even there some judges are, some independent judges are passing some good independent bold orders. As I said, you see the process of selection as you go further up in the judicial ladder is such that usually independent and bold judges are weeded out. And in the Supreme Court, as I said, that if the Chief Justice can somehow be influenced, then you can ensure that important cases don't get listed before very independent judges, whatever independent judges there are in the Supreme Court, or strong and independent judges. So therefore, this is the reason why this happens.
There are a couple of questions on emergency-like situation here. Isn't the present continuous lockdown amounts to an emergency-like situation? And it continues, keeping in view all the events happening now. For example, CAA, revocation of Article 370, lack of transparency in PM care, and many more. Isn't this all indicating to constitutional dictatorship? Do you see a solution to this?
Yes, unfortunately, Mr. Suhash Palshikar had written a very good article on this in the Indian Express about a month ago, where he said that this lockdown is leading to and would lead to a severe erosion of democracy in this country. And we are seeing this happening everywhere. I mean, PM Cares Fund is one example, electoral bonds. Of course, electoral bonds came earlier, but PM Cares Fund is a scandal. That you have a public fund which the Prime Minister is collecting public money from PSUs, from the government, from the public, from companies, etc. And there is no transparency at all about that. It's absolutely astounding. As somebody pointed out, it's a daylight robbery. So these are few examples, but there are many, many examples of how, including the arrests of these activists, etc. You see, because the courts are also in lockdown, and therefore it's very difficult for them to even apply for bail and to get bail in these circumstances. Therefore, these activists are being targeted during this lockdown so that they are helpless and unable to access even courts. And as I said, you see, when there is a very strong government and in an emergency-like situation like today, courts in any case become weak. When they see a very strong government, then this is what is also happening.
One more question here. What is the role of an advocate practicing in subordinate courts to access the instant justice in case of violation of fundamental rights?
So even in subordinate courts, one can raise those issues. It is not that the subordinate courts are, of course, the fundamental rights are violated. Subordinate courts are fully entitled to, especially in the case of these arrests, etc. They are fully entitled to. They may not be able to institute a general inquiry or investigation into these arrests and the victimization of the victims themselves, which the High Courts and the Supreme Court can do. But certainly in individual cases which come up before them, they can. They can't do PILs, but they can do they can certainly enforce fundamental rights of individual citizens which come up before them.
So there is one more question. I think you answered it, but I'll repeat that question. Why Honorable Supreme Court is silent on Safura Azargo's arrest? It's inhuman to arrest and put a pregnant woman in a crowded Tihar jail during pandemic time. It's utterly failure of our Indian judiciary. All of a sudden, under UAPA, they have arrested many activists of Jamia, Pinjara Todd, and women wing leaders. Is there any solution to this question?
Yes, it's very clear that the Delhi police is victimizing innocent students and activists and Muslims. They have arrested more than 1,000 people during this lockdown in connection with either the Delhi riots or the CAA protests. Now, unfortunately, because people have lost confidence in the Supreme Court, therefore many of these issues are not being taken to the Supreme Court. They are sometimes very rarely being taken to the High Court, but mostly people are applying or trying to apply for bail in the lower courts themselves. because of the loss of confidence, public confidence in being able to get proper justice from the High Court or the Supreme Court of the Supreme Court. Now, solution to this is not very easy. I think people should approach the high courts for this victimization in the first place. A kind of composite petition should be filed seeking an independent investigation into this victimization. But unfortunately, even the high courts are not yet fully functioning. You see, even the Delhi High Court is still functioning by video conferencing, etc. They're not very satisfactory hearings. This kind of a case needs a proper satisfactory hearing. I don't have any really good solution for this problem.
There's one more question here.
Guru Prasad, 1 second. We'll take 3 more questions only. So please prioritize on the questions which are not repetitive, and we'll have to then end. Thank you.
Is it fair to fall back on judiciary on matters of executives? The question follows: in the name of regulatory functions, isn't SC Supreme Court overreaching its limit? If these things continue, won't the orders of SC lose value owing its difficulty in its implementation?
No, I don't agree with this view. You see, it is the job of the Supreme Court to protect fundamental rights of the people. Now, in a case like, say, for example, this lockdown and the migrant workers, clearly their fundamental right to life is being violated if they are being left high and dry without any money or food, etc., and without any means of traveling back home. All those are their fundamental rights. So therefore, if the state's action is leading to the denial of those rights, that is, the lockdown is leading to the denial of those rights, it is the job of the courts to interfere. And they may not say that you end the lockdown, but they can certainly say, and they must say, that you ensure that these people have some food and money and that they are able to travel back home in a safe manner. So therefore, that is the traditional and the accepted role of the judiciary under the Constitution. There are certain other things which can be said to be a matter of policy, of executive policy, with which the court cannot interfere or should not interfere. For example, if the issue is whether the lockdown should be continued or not, the court may say, all right, that's a matter of policy. Whether it should be continued, it's ultimately for the government to see whether what is more important. But even if you have the lockdown, you cannot have it in a manner, you can't enforce it in a manner which violates the right to life of people. So.
Okay. There's one more question. Appointment of judges is in the hands of judges, but impeachment is with the legislature. Do you feel that this position of influencing the judges to qualify political popularity in reaching a constitutional construction?
Unfortunately, we have seen that impeachment is not a practical remedy at all. You have to get an impeachment motion signed first by 100 MPs. And usually 100 MPs are not willing to sign an impeachment motion because every political party has cases pending in the courts, etc. The ruling party is quite happy to play along with the judiciary, and the opposition is afraid because it has cases of their MPs or their political parties pending before the judges, and they fear a judicial backlash. That is why I've been saying that instead of having the process of impeachment, we need to have a fully independent and high-powered judicial complaints commission, which should have the authority to examine complaints against judges and take action against them. It's true that appointments are now primarily with the judiciary, with the collegium. But we are seeing that this government is refusing to appoint judges who are recommended by the collegium if they are seen to be either inconvenient or independent or bold. We are seeing this repeatedly, or if they come from minority communities, etc. This government is refusing to appoint them and just sitting on those appointments. Now the judiciary, the Supreme Court can issue a mandamus to the government to appoint them, but so far they have not done so, unfortunately.
Okay. I think you spoke about active citizenry, but still there is a question. In this context of SC not being proactive, what can a common man or a woman do? Is helplessness the only way out, or can the common man, woman do anything more than remaining just helpless? And one more question, which you already spoke, I think, why can't there be courts in villages? Is it not possible? I think you can combine these two questions.
I'll answer the second question first. Yes, courts can be in the villages. In fact, the Gram Nyalaya Act requires courts to be in the sub-tehsil level, at the block level at any rate, and some kind of circuit courts or moving courts in the villages also for petty normal cases, criminal as well as civil cases. So those Gram Nyayalayas need to be established. And what was the first part of that question?
Is this context of SC not being proactive, what can the common man or woman do? Is helplessness the only way out? Or can common man or woman do anything more than remaining just helpless?
Yes. No, helplessness is not the only way out. Right now, of course, during the lockdown, you can't have physical protests, etc. You can't have physical gatherings, but you certainly can be active on the social media, on the internet media. There are a number of people who are doing very good work on the internet media, on the social media, on YouTube, etc. In order to educate the people about what is happening. That's what we can do and we need to do. Build public opinion on these issues. Educate them and build public opinion about the role of the judiciary, how it has failed, what needs to be done by way of reforms, etc. That education needs to be done by all of us.
Guru Prasad, last question, Guru Prasad.
I think almost all questions we have done, sir. Important questions. There's one more question pending. Is like Rashekar asked, can you please elaborate on how the appointment of judges is done, and can there be more appropriate procedure for that?
Yeah, you see, appointments earlier were done by the government. They were selecting people, and at that time the complaint was that in order to become a judge, you don't need to know the law, you need to know the law minister. But thereafter, the collegium or the Supreme Court took over the power itself by a creative interpretation of the word consultation. But even now, we are seeing that the collegium, when it selects judges, there is no transparency. It's very arbitrary. There is a lot of nepotism in all this. And still the government interferes, because even after the collegium has made its recommendations, we find that the government still does not appoint bold and independent judges and sits on those recommendations. So that's why we need to have a Judicial Appointments Commission, which is a full-time independent body and whose recommendations are just acted upon.
Thank you, sir. Thanks a lot. We thank Mr. Prashant Bhushan to accept this invitation from Gauri Media and for delivering this lecture. Thanks a lot, sir. And we also thank all the participants who are here for more than an hour. ಸ್ನೇಹಿತರೆ, ಎಲ್ರಿಗೂ ಕೂಡ ಈ ಒಂದು ವೆಬಿನಾರ್ನಲ್ಲಿ ಪಾಲ್ಗೊಂಡಿದ್ದಕ್ಕಾಗಿ ಧನ್ಯವಾದಗಳು. ವಿಶೇಷವಾಗಿ ಪ್ರಶಾಂತ್ ಭೂಷಣ್ ಅವರು ಅವರ ಎಲ್ಲ ಬಿಡುವಿಲ್ಲದ ಇದರ ಮಧ್ಯದಲ್ಲಿ ಬಂದು ಇದರಲ್ಲಿ ಪಾಲ್ಗೊಂಡಿದ್ದಾರೆ. ಮುಂದಿನ ದಿನಗಳಲ್ಲೂ ಇದು ನಿರಂತರವಾಗಿ ಈ ರೀತಿಯಾದಂತ ವೆಬಿನಾರ್ಗಳನ್ನ ನಾವು ಸಂಘಟಿಸ್ತಿರ್ತೀವಿ. ಇದು 3ನೇಯ ವೆಬಿನಾರು. ಆರಂಭದಲ್ಲಿ ಗುರುಪ್ರಸಾದ್ ಅದನ್ನ ಹೇಳಿದ್ರು. ಇನ್ನು ಹಲವಾರು ಜನ, ಕೆಲವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಕೀಲರನ್ನು ಸೇರಿದಂತೆ, ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರುಗಳನ್ನು ಸೇರಿದಂತೆ ನಾವು ಮಾತಾಡ್ಸಿದೀವಿ. ನಮ್ಮ ಪತ್ರಿಕೆಯಲ್ಲೂ ಕೂಡ ಕುರಿತು ಲೇಖನಗಳು ಬರ್ತವೆ ಮತ್ತು ಇಲ್ಲಿ ನಾವು ಕೆಲವು ವೆಬಿನಾರ್ಗಳನ್ನ ಸಂಘಟಿಸ್ತೀವಿ. ಮುಂದಿನ ಸರಿಯಿಂದ ಈ 100 ಜನರ ಲಿಮಿಟ್ ಏನಿದೆ ಅದು ಕೂಡ ಇಲ್ಲದೆ ಇರೋ ಹಾಗೆ ನಾವು ನೋಡ್ಕೊಳ್ತೇವೆ. ಒಂದು ಪೇಯ್ಡ್ ಅಕೌಂಟ್ ನ ಅಗತ್ಯ ಇತ್ತು. ಮುಂದಿನ ಸರಿಯಿಂದ ಅದನ್ನು ಮಾಡ್ತೀವಿ. ಬಹಳ ಜನಕ್ಕೆ ಇದ್ರೊಳಗಡೆ ಬಂದು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ, 100 ಜನರು ಲಿಮಿಟ್ ಇದರಿಂದ. ಎಲ್ರಿಗೂ ಕೂಡ ಧನ್ಯವಾದಗಳು, ಭಾಗವಹಿಸಿದವ್ರಿಗೂ ಕೂಡ ಧನ್ಯವಾದಗಳು. ಥ್ಯಾಂಕ್ಸ್ ಅ ಲಾಟ್.